Hello and welcome to the UAW-FCA-Ford-General Motors Legal Services Plan webinar on powers of attorney and guardianship. My name is Elaine Eiselman. I'm the Assistant Director of the plan, and I'm going to be asking some of your questions to our presenters today. Today we're going to be talking about powers of attorney and guardianship, and our goal is to give you an overview of both legal procedures. We're going to begin by speaking about the powers of attorney. And I'd like to introduce you to our presenters, Carolyn Bernstein and David Savard. Carolyn, or Carrie, as she is known to us, earned her law degree from the University of Wisconsin in 1990. She worked for the former UAW Legal Services Plan for almost 25 years, starting as a staff attorney at that plan's Flint office and eventually becoming a managing attorney. Today, she's the managing attorney for the new plan's Saginaw office. Carrie's public service extends into the wider community, where she's won several awards for contributing her time at Legal Services of Eastern Michigan, helping low-income clients. Welcome, Carrie.
Thanks.
And Dave Savard, our other presenter, is his first job involving the UAW is actually as a proud member of the UAW Local 372 at the old Chrysler Chemical Plant in Trenton, Michigan, making breaks while attending Eastern Michigan University. He earned his law degree from the University of Toledo in 1982, and after stints with the Monroe County Prosecutor's Office and Monroe County Senior Legal Services, Dave joined the former UAW Legal Services Plan in 1985 as a staff attorney before becoming a managing attorney. Today, he's the managing attorney at the plan's Wayne, Michigan office. Welcome, Dave.
Thank you.
Thanks for joining us. Both Carrie and Dave have extensive experience helping UAW members with their legal matters, and we are very glad to have them here today. Carrie and Dave, we've received a lot of questions about powers of attorney and guardianship, and I think we should just dive right in and start out by asking you to tell us exactly what a power of attorney is. Dave?
Well, a power of attorney is a document that you sign that appoints someone to take care of business for you. It could be business that's general in nature, banking, cash and checks, paying bills. It could be government benefits issues. That would be a broad power that covers a lot of different things. Powers of attorney can be used for one-shot deals, to do a real estate transaction. The important thing about a power of attorney is that the person who signs it must be competent to sign it. They must understand what they're signing. They must be capable of signing it physically. And once that has been done, then the power of attorney goes into effect, and that person can help you with your business matters. The other important thing that you need to understand about a power is that when you give a power, you're not giving up your rights. You are just merely allowing someone else to take care of things for you if need be. So you are still in control of your assets, of all of your business matters. The power can only be used as is needed. It can be used for only those things that are specifically authorized in the document. The document itself must be in compliance with the law in the particular jurisdiction or state where you live. So it's important that the power comply with those laws, and they must be signed in compliance with those laws. Some states require a notary to be involved in the signature, maybe just a couple of witnesses, depending on where the power is and the type of power that we're talking about.
Thank you. Carrie, are there different kinds of powers of attorney, and what are they for?
There are a number of different kinds of powers of attorney, and you might not need all of them, but you might need more than one. For example, there's a durable power of attorney. As Dave mentioned, it's a general document that would allow you to appoint another person called an agent to give them authority to transact your personal business for you. So that would include things like your banking, or speaking to your creditors, or paying bills, or negotiating with an insurance company, or filing claims on your behalf. Basically, anything that you could do over your financial affairs, you're giving authority to this person to do for you, unless the document says it's limited for some reason, like maybe they can't set up a joint account. So that's one kind of a power of attorney. A second kind of a power of attorney that people often use is a durable power of attorney for health care. In this document, you would state who your agent is to be, the one who is going to make decisions for you if you're ever incapable of making medical decisions for yourself. So two doctors would have to find that you're incapable of making your own medical decisions. Obviously, if that didn't happen, you can make your own. But then at that point, your agent would be able to discuss your medical status with the doctors. They'd be able to decide what hospital you go to, what treatment you should receive, whether or not you're going to get surgery. And the document can provide guidance about what you might want at the end of your life in terms of life support. So it may say that you authorize them or that you instruct them to take you off life support, or it could say that you want to remain on life support, but that's an important function that a healthcare power of attorney could put in place for you. In addition, there are more limited powers of attorney. There's one for real estate transactions, for example. If you just need somebody, like a child perhaps, to be able to sell your home. Say you're moving away and you don't want to have to stick around for the closing, you could give a limited power of attorney to your child and allow them to attend the closing for you and sign all the papers for you. And then another example of a limited power of attorney would be a child care power of attorney, where perhaps you want your parents to take your kids on vacation or enroll them in school. Their grandparents can't do that unless they have a written power of attorney in place. And then they could talk to the doctors, get the kids medical care that otherwise only you could authorize to be provided.
I've heard about springing powers of attorneys, and how are those different from the ones you've described?
Well, a springing power of attorney is a power of attorney that only goes into play when the person has become incompetent. So you would sign the power of attorney. It wouldn't go into effect immediately. It would go into effect later on if you became incapacitated. So the problem, though, with those powers of attorney you need to understand is that you need a couple of doctors in most cases, or at least a doctor, depending on the jurisdiction, to indicate that you can no longer handle your own affairs. At that point in time, power of attorney would then go into effect. One of the problems, though, with that is that, there's logistical issues and problems with that. If you have to go running around to find doctors to declare a person incompetent, it's going to mean getting the person that you're overseeing to the doctor, getting the doctor letter before anything can be done using that power of attorney. So there's some logistical problems with that.
Okay. Now that we know about some of the different kinds of power of attorney, when would we go about getting a power of attorney? When do you think is a good time to start that process?
Well, a good time to look at a possible power of attorney is when you do your entire estate plan. Typically, when we do estate plans for folks, we're doing wills, maybe trust, depending on what their needs are. As part of that process, we also will do the powers of attorney. We'll typically do one for the financial matters, and we'll also do one for the medical issues, medical decision-making. So that's the time when a power of attorney might be needed. If you're getting ready to go into surgery, say, or you're having health issues, it's starting to get up in years, maybe there's some health issues that are coming up. Well, it's a good time then to get that power of attorney done, to make sure that the medical authority has been granted to people to make a decision for you. Oftentimes, if you go to a doctor, they'll ask you if you have an advance directive. That's sometimes referred to as the medical power of attorney. And then, of course, there's other times when powers of attorney might be needed that Carrie mentioned. Could be where you're getting ready to do a real estate deal. You won't be around for that. You won't be able to attend the closing. You can designate a person to go in and sign the paperwork for you. And also child care powers of attorney sometimes are needed. If you're grandma and grandpa and you're going to be taking care of your grandchild for a period of time, maybe they're going to move in with you, or maybe it's a situation where there's just a family vacation, a long vacation for 2-3 weeks. It would make sense to have that power of attorney in place in case you had to seek medical attention for the child. Those types of powers of attorney are limited just to those particular transactions.
Okay, you've convinced me powers of attorneys can be very useful, and I might want to get one. How would I decide who should be given my power of attorney? What should I think about?
It's an important decision, and you should make sure to consider all your options. When you pick somebody, the person who's going to be your agent needs to be absolutely trustworthy and reliable. So trustworthy in terms of making sure that this is somebody who is not going to take advantage of you, who's not going to spend your money on themselves. That would be a violation of their responsibility to you. Their job is to put your needs ahead of their own needs And their job is also to make sure to take into consideration what you want them to do, and they have to be able to follow your wishes as well. When you're naming a power of attorney, consider, are they able to pay their own bills on time? Are they the ones you would call if you're in the hospital? Are they the ones that can talk to the doctors and demand that you get the treatment that you need? That might be a good person to select as power of attorney. And you can also designate somebody to be the backup. So if the first person you've appointed is unwilling or unable to act, then the alternate person can step up and do those jobs for you as well. You have to discuss this with the people you're appointing, though, because not everybody's willing to take these jobs on for you. It's a big responsibility, and you need to make sure that they are willing. You don't want to blindside them. They need to know about it in advance and say, yep, I'll help you out in a pinch. And in some cases, realize that it does not have to be a relative. If there's a trusted friend or a distant family member, maybe that person is willing to do these jobs for you, you can certainly consider them.
Okay, following up on your latest comment about not having to be a relative, we have a question. The questioner says, I take care of a union brother and good friend. This is obviously a very helpful person. He wants me to be a spokesperson when he is ill. Once we had a letter written giving me the power of attorney for him medically, and it was notarized. Since then, he's moved, and my husband and I have also moved to another county. Do we need to redo anything?
Well, I think first off, you'd probably want to have an attorney, one of our attorneys, look at that document, whatever it was that was signed, to determine if it's in compliance with the law, to make sure that it's up to snuff as far as being capable of being used and something that would be recognized. So typically in a case like that, we would probably prepare a new power, get it updated. If the person was capable and competent to sign, they could sign that new power. We'd make sure that it's in compliance with the state laws, that it has the necessary witnesses and or notary on it if need be. We'd also make sure that, things hadn't changed, that it still was the type of document that that person would want, and authorize the type of medical care and treatment that that person wanted.
Okay, thank you. We have another question from one of our attendees. I've been named the power of attorney for my mother. What do I have to do?
Well, I think the most important thing to do is to really sit down with your mother and talk to her about her wishes, right? You want to know that you're acting in a way that she wants you to act, and you don't want to take steps that she doesn't want you to take. So you also have to read the document carefully. You have to understand what the document allows you to do, and if there are limitations in the document, you need to be aware of those. If you have trouble with that, you might want to call us. We'd be happy to discuss it with you, go through it, make sure you do understand what you are required to do and what you're not. You must also be prepared to account for the assets of the person you're responsible for. If you're acting for your mother and she's got money in the bank and you start writing bills out for her, you need to be prepared to show the money going into that account and the money going out, because you wanted to, be able to show that the money is being spent on your mother and not on yourself or not on your own family. So you got to keep your money separated from your mother's money, and you got to be prepared to keep accurate records and receipts. When you're thinking about signing legal documents on behalf of your mother, make sure it's in your mother's best interest when you do that, and then also never sign just your own name on those documents. You don't want to be the one personally responsible for what is actually your mother's matter. So if you're signing on behalf of your mother, you would sign your name, say John Doe, as power of attorney or as attorney in fact for Mary Doe, so that anyone looking at that understands you are binding your mother, you're not binding yourself. So don't ever sign just your own name on the document.
Sounds like important advice. Kind of following up on that, my mother changed her mind and appointed me power of attorney instead of my brother. What do we need to do to make sure that the new power of attorney is honored, Dave?
Well, the first thing you'd want to do is to have Mom sign a revocation or revoke that prior power. It's important that that be done. The documents that we use often have language in there on the new power of attorney that indicates that this hereby revokes any priors, but it is a good idea to get a separate revocation done, just so that can be given to whoever it is that the brother may have been working with, somebody down at the bank, say, or a doctor's office, so that they know that this power, the old power, has been revoked, and that there's a new power in place and that you're acting on behalf of mom now. It's also important to let your brother know that this has been done. A lot of times people are reluctant to do that, but it's a necessity. You have to let the old agent, the old power of attorney, know that they no longer have the authority. Let everybody that that person may have been dealing with know that it's been revoked, and that's a real important thing that needs to be done.
Okay. Carrie, we have somebody who's considering naming both of his children as joint powers of attorney. Is that a good idea?
We don't recommend that. We think that for most people, it's really a cumbersome and difficult arrangement. If you consider that some banks would require both of them to transact business together, if they had to get legal assistance, they would both have to go together. And so most people aren't really able to do those kinds of functions together. So it's best, we think, to appoint one person and then maybe another person as the backup. In addition, you might find the bank simply won't accept a power of attorney that names two people at the same time. And medical powers of attorney, that's especially important, I think, just to have one person and then one person as a backup. The reason why is, if you think about it, the doctor can't possibly follow the instructions of two different people if they don't agree. So then they would be stuck. So, and in addition, in some states, the law is going to specify that you can have one person at a time doing it. So, but again, you can name somebody as a backup in case the first person you've appointed can't act for you.
Okay, that sounds like good advice. Next question we had is, who should be holding on to the power of attorney itself?
Well, I think one of the things that's probably the best practice is that when you grant a power of attorney to someone, is that you hang on to it. You may change your mind later on, so you might want to do something different, as we talked about before. So you can hang on to the power of attorney, but it's important that you let your agent, your power of attorney, know where it is so that it can be obtained when the time comes. So you put it in a good, safe place at home, maybe where you keep your other important papers. Let your agent know where it is so they can retrieve it. In some cases, though, it's necessary that that power of attorney be turned over to the person right away. Maybe it's for the child care situation where you've granted a power to someone to take care of your child. You need to get that to them right away so that they can use it when you're gone, if you go on vacation or your child is going off with grandma and grandpa, say. Another instance where the power of attorney might be needed immediately and turn it over to the person is if you're doing the real estate deal, where you've granted them power to go to the closing. So they're going to obviously need that document when they go to the closing to sign those papers on your behalf. But for the most part, I think it's a good idea to hang on to it, keep it at home in a good, safe place, and then it's ready to retrieve when the need comes.
Okay, thank you. We've had a lot of people ask this next question. Does a power of attorney ever expire?
It does. One thing to know is that it always expires when the person who appointed the agent, when that person dies. So, a lot of times people ask me, well, I thought the power of attorney is specifically for transacting business after the person dies. That's not the case. That might be the executor of a will, but the power of attorney is so you can name the person as your agent who's going to help you while you're living. But it does terminate when you die. And the other thing to know is that it terminates, of course, when the person revokes it or chooses a new person to act as power of attorney. So under those circumstances, it would expire. And sometimes if it's a limited power of attorney, like a child care power of attorney, by law, it's going to expire after a certain number of months. And then you'd have to renew it if you wanted to continue to confer that authority on somebody else.
I have just a regular power of attorney, say a durable power of attorney. Is there a limit to how old that can be? How long does it last? Unlike a child care, which has limitations.
As Carrie mentioned, they do expire under certain circumstances, but a power of attorney can also get stale. It can get old to the point where, if you have a 10 or 15-year-old power of attorney, it's very likely that you take that down to the bank, they're not going to want to recognize it. They're wondering, well, gee, is this still what this person wanted? And and has there been any other document done after this? So, as a general rule, after a couple, 3 years, they tend to start getting stale. And, as far as your legal benefit goes, we can update powers of attorney. It may be no different than the one you have right now, appointing the same agents, same authority, same powers, but it's a good idea to look at those every now and again and make sure that they don't get too old. If you have an estate plan done, wills, trust, whatever the case may be that you need, we typically will update the powers of attorney at that time, even if there's really no changes in terms of who the agents are or the authority granted.
Okay, thank you. We have another person who asked this question. She recently lost her spouse, and her question is, does she now need to change the power of attorney if there's a contingent or a secondary person named?
So the contingent person named should have the authority to act using that power of attorney. And so you don't have to renew it right away, or you don't have to change it right away. But we recommend that you do, because there may be other things you need to change about your estate plan. When a person close to you dies, that's a good time to have everything reviewed, maybe your whole will, how things pass at your death, and it is the better time to update your powers of attorney, because then you'll be able to appoint a new person to be the primary person, and then a different person perhaps as the alternate, so that in the event of another emergency, you've got something in place.
Okay, thank you. You've sort of addressed this question, but somebody has asked, does the power of attorney need to be filed in probate?
No, power of attorney is never filed in probate, doesn't have to be recorded or filed anywhere. It's a voluntary document. It can be revoked at any time, so it's not involved in the court. It doesn't have anything to do with the probate court. We'll talk a little bit more about that later, what types of cases are in court. But as far as the power of attorney goes, no, that would not be filed anywhere.
And by the time you're in probate court, would be after somebody dies?
Well, if you're in probate court, it might be because a guardianship is necessary. We'll talk about that in a little bit.
Okay.
But typically, the will would be filed after a person dies. That's a whole other subject, but powers of attorney, no, we wouldn't
So
file
the power of attorney would have expired at that point?
That's exactly right.
Okay. I have a couple questions on a kind of a similar topic. I'll ask both of them at the same time, because I think the answers are going to be pretty close. So the first question is, must a power of attorney written for financial matters specify the ability to change a beneficiary of record for life insurance? I recall a power of attorney trying to change a life insurance beneficiary that was denied because the power of attorney document did not specify that right. Second question, what about making changes to the grantor's will or beneficiaries using the power of attorney?
So being an agent as a power of attorney does not give you the authority to change another person's will. The only person who can do a will is the person whose will it is. So a power of attorney is not going to let you do that. Even if you want to change the beneficiaries of somebody's life insurance policy using a power of attorney, we don't recommend it. It doesn't look good. It looks as though maybe you're trying to benefit yourself, you're trying to substitute your wishes for where the money should go, and really that decision belongs to the person whose insurance policy it is. So we don't recommend that you ever use a power of attorney to do those things. And in addition, you should be aware that the power of attorney document itself might restrict you from doing that, and so you might not find that the insurance company would let you do it.
Okay. So, Dave, if I want a power of attorney after hearing this, what should I do?
Well, you know where to call. We've got the 1-800 number. It's up on your screen there. We can do a power of attorney for you at no cost. We can do any other legal matters that you might need. There's different types of coverages for different matters, but as far as the power of attorney goes, that's no cost. You call the 1-800-482-7700 number, and we'll get you hooked up with attorneys that can help you get that taken care of.
Okay, great. We had a couple questions that sort of will transition us into our discussion about guardianships, and I want to read both questions to you and see if you can answer those. First one is, I'm a caregiver for my dad, and I have the power of attorney. How should I go about getting guardianship? The second question is, my mother's in a nursing home, and the nursing home staff is telling me that I have to file for guardianship?
Well, that's the whole point of having powers of attorney. If you have a power of attorney, you should not need a guardianship. So perhaps the nursing home is misunderstanding. Have you shown them a copy of the power of attorney? If you show it to them, they will often accept that or maybe ask to speak to the person's boss. But the whole idea of powers of attorney is so that you don't have to go to court. And even if the document is stale, even if it's old, you could certainly press to have them recognize it, especially if the person who appointed you no longer has the ability to make their own decisions. They don't expire usually. If there's no expiration date in them, you can certainly push to have them recognized so that you can avoid having to go to court.
It kind of leads us into our discussion on guardianship. And when is a guardianship needed? We talked about powers of attorney, but you did indicate sometimes we would need to go with a guardianship. Can you explain that to me?
Well, a guardianship is needed in a case where the person is already incompetent. If the person is already incompetent, it may be too late to get a power of attorney done. If they're not physically or mentally capable of understanding what's going on, it's probably too late to do a power of attorney. So that's when the guardianship comes into play. Another time when a guardianship might be needed is that the person named in the power of attorney is no longer able to serve. Maybe they've passed away, or maybe they've moved out of town, and there's really no one there available to do the job anymore, and the person is no longer competent. Well, another power of attorney, it's too late to be done. The person has to be competent to sign a power of attorney. If they're not, that's typically when the guardianship may be what's needed. Also, there's situations where a person has, mental health issues, substance abuse issues, and maybe they're not willing to sign a power of attorney. They don't think they need any help. Well, maybe their, life is a mess and they're not, maybe they're a danger to themselves or other people. Well, then you may need to petition to be guardian at that point in time. But you have to understand and recognize that there has to be sufficient grounds for a guardianship. That the person is completely incapable of handling their own affairs. You have to establish that in court, and we'll talk a little bit about that in a minute. But another option here, or another situation where guardianship might be needed, is if there's a minor child that's been placed with you. Maybe the parent drops the kid off and disappears, and now here you are with a child, maybe your grandchild, and the parents are not around. In a case like that, you'd have to go to the court and petition to become the guardian over that child. If a child care power of attorney is not possible because the parent has just vanished or taken off. So in a case like that, you may be looking at a guardianship possibility.
Okay. So here we are. We need to file for a guardianship. What's going to be involved in that, Carrie?
So it is a formal court procedure, and what that means is that it started with paperwork, and you usually need a lawyer to represent you doing it. And then it's up to the court to make a decision about who to appoint. So how do they do that? They look at whether the person who needs the guardianship is truly incapacitated. Do they have competency to do their own power of attorney? Can they make their own decisions? You might need medical support for why this person no longer has the ability to make their own decisions. The guardianship papers are going to outline the responsibilities of the person who's getting appointed. You may have limitations on what they can do on behalf of the ward. You may not be able to sell their home without a court approval, something like that. Generally, the person who's appointed, if there are money issues involved, that is called a conservatorship, and there would be accounting requirements. So the conservator would be responsible for identifying the assets of the person and for marshaling those assets, for taking control of them, and then for spending them on behalf of the person who you've been appointed for. So it's important to recognize that the court has the authority to appoint or discharge the person appointed, not like a power of attorney, which is revocable if the person changes their mind about appointing you. If the court appoints you as a guardian or conservator, only the court can change its mind about that.
Carrie was talking a little bit about guardianships and conservatorships, and you indicated guardianship is control over the person, and the conservatorship control over the assets, and we had a question about that. Somebody has indicated that they're the guardian of a person, but somebody else is the conservator, if they name the conservator. And the guardian is concerned that the conservator is not paying the ward's bills. Is there anything he or she could do?
Well, as a practical matter, the guardian can go to the conservator and talk to the conservator. And if you want to call it confronting the conservator, then that's what they can do. And say, hey, what's going on here? Why aren't these bills being paid? You know, I've got a job to do, but so do you. If that doesn't work and the job still isn't being done by the conservator, well, then the guardian can go to the court, file a petition within the court to maybe have that person removed, maybe for them to take over that role as well. So there is legal recourse if a conservator isn't doing the job. And if a conservator isn't doing the job, well, they have reporting requirements. They were supposed to report all the money going in and going out. It's going to be evident when those reports are filed that certain things that were supposed to be done or needed to be done aren't being done. And the court can act accordingly to take care of that problem.
Okay. So we've decided that mom or whoever is going to need a guardianship. Should I just leap right into it, or what should I know? What should I be thinking about?
Well, you have to be prepared for the fact that this is an important and big responsibility, and you have to ask yourself, am I the right person to do this job for my mom? Is there somebody who maybe is situated closer to her or is already doing these services for mom? Would that person make more sense? Do I want to do it? Am I able to do it? So if you have trouble paying your own bills on time, maybe you're not the best person to take the responsibility for paying your mom's bills on time, and that would put a big burden and strain on you. Are you able to see your mom regularly? So you need to be the one to go and visit her, make sure she's being well taken care of, that she's eating properly, has the proper medical attention. You're the one that they're going to call in the middle of the night if she goes to the hospital. Is that okay with you? Can you handle that responsibility? So do you understand your obligations? All of these things are going to come into play. And of course, if your mother has power of attorney, that person has priority to do these things instead of you. So you're only going to get appointed as guardian or conservator if you can show that the person appointed under the power of attorney is not fulfilling their responsibilities to her.
Okay. What if more than one person is seeking guardianship over the ward? Who decides who's going to be the guardian?
Well, the court would ultimately decide that. I mean, as a practical matter, it makes sense for the family members to talk it out and decide, if possible, who would be the best person available and capable of doing the job. But if you have brother versus sister in a situation where they can't agree, then somebody will probably file a petition. That petition can be challenged. The court will decide, based on what's filed and what the circumstances are, who is best equipped to do the job. What the parents say, if the parent is the ward, wants is going to be certainly a part of that consideration, even if the person is very feeble and frail and maybe not quite capable of making decisions necessarily. That is still a consideration that will be taken into account by the court. And in many cases, the court will also appoint a third party to do an investigation, what's called a guardian ad litem in some states. That guardian ad litem will look at the situation, talk to the ward, talk to the people involved in the petitions to try to determine what is the best situation, the best remedy available for mom, say. So these are all part of the considerations that will go into a contested matter.
Thank you. This is a situation that we hear about quite often. My spouse has dementia. We did an estate plan. Do I still need to get guardianship to make sure everything is taken care of and our bills are paid?
Well, the first thing you should do is look for the packet of your estate planning documents, because 99 times out of 100, you're going to find in that packet powers of attorney that were already put in place. At least if you came to the legal services plan, you will. And so you may already have the power of attorney documents that you need, and then you could, if you have questions about them, call us and we can explain it to you. Even if you can't refresh them, even if the person no longer has the ability because of their dementia to refresh them, you could still try to use the old powers of attorney. But in terms of updating them, maybe even someone with dementia still has the ability to understand and form their own opinions and decisions. And so we could certainly try to get newer ones for you if you needed to. You would want to take all those steps before you would resort to a guardianship. And frankly, lots of times people don't need a guardianship. If your spouse is in a nursing home and you have everything held jointly, and then you might not even need it. The doctors might let you make decisions even if you don't have a medical power of attorney. And you can still transact business from the bank account. So I always say don't bother with the court proceeding unless someone tells you no. And if you can't do something, that's the time when you might have to resort to a court proceeding.
Yeah, one thing I'd add to that as well is that in many cases with husbands and wives, they can transact business for one another even without a power of attorney. If both names are on the accounts, if both names are on the house, on the mortgage, that they can typically transact and deal with any kind of business that's necessary, even without a power of attorney and certainly without a guardianship.
Okay, thank you. So if it's determined a guardianship is needed, how can the legal services plan help me?
Well, we gave you the number before. We'll give you that number again. You know, we certainly invite you to give us a call. The number's on the screen there, 1-800-482-7700. As far as guardianships go, in a guardianship situation, if that's the only alternative, you know, once again, Plan A is that power of attorney. But if there's no other alternative than a guardianship, the plan can provide a low-cost referral to an experienced attorney. We have a network of attorneys around the country that can do that job if need be. And even before the referral is made, in many cases, we'll be able to look at all the options, discuss what the proceeding involves, and talk about all the alternatives and what might be the best course under the circumstances.
Thank you. Thank you, Dave and Carrie. This was very informative. I think we all learned a lot today. Again, if anybody has any questions about their specific matter or they have a case they'd like to open, call our 1-800 number, and somebody will assist you and get you to an attorney. Thank you for listening.
Thank you.
Thanks.